Everyone. My name's Michelle Dexter. I'm here with Keystone Law Firm. I'm an estate planning attorney here, and I handle most of our estate plans as well as some trust administration, probate, guardianship, conservatorship matters, those types of things. Thank you so much for joining us on this webinar. We are thrilled to be doing some webinars to present information to our community and just help everybody have a better understanding of estate planning options, things to do with regards to your estate plan, and just help get information out there in the community with regards to what we do. So we really appreciate you joining us this morning. This webinar is being recorded, so it will be available on our YouTube channel probably later on this week after Alexis has the opportunity to go ahead and clean that up and get that posted. We've got some other webinars on there as well, and I'll share that information with you at the end of this webinar today. First thing, of course, we're a law firm, so we want to have our disclaimers. This information is really being provided for informational purposes only. We're not providing any legal advice as part of this presentation. If you do have questions, please use the chat feature. There's a chat feature down towards the bottom of the Google Meet that will allow you to do that. It's just me kind of managing what I'm sharing and managing those questions. So more than likely, I'll try to answer those at the end, time permitting. And lastly, I want you to remember each of your families are unique. Your situation is unique, and you know these people better than we know these people. So we don't want you to take this as a one-size-fits-all. This is more intended to help you know all of the different things that you can share, and you can kind of choose what's appropriate to share for your family, okay? How much to disclose, right? Disclosure of the information will really vary depending on your family dynamics, the stage of your life, and your relationships with the people that are involved, okay? This webinar is going to share information that may be shared, but you, again, should decide which is appropriate for your situation, okay? Whether you're married, whether you're on good terms with your beneficiaries or your kids, all of those different types of things kind of play into what people are wanting to disclose to their family members. So one question that I often get is, should you give copies of your documents to your agents and or your beneficiaries? Generally, I say no. Let them know that the documents exist. For our firm, our clients get a 3-inch blue binder in most cases. Let them know that those documents are there. Let them know how they find them when they're needed. In cases of emergency with Keystone Law Firm, we keep a scanned copy of those documents, so you could give them our business card. And when would those people be using those documents, right? If you are a married couple and you guys would be each other's initial agent, your successor agents aren't necessarily needing to know all of that information immediately, but they should be aware in the event that both of you are in an accident or something. If you're a single individual, then letting your agent know where those documents are, what they're going to have authority to do, what types of steps they should take is generally a good thing to let them know, okay? The other reason that I don't recommend giving out copies to everybody is because those documents may change over time. Excuse me. And if you've given out copies and you make changes, you're going to have to go and get those copies back from people. And that may prove to be an awkward conversation, right? So if you've changed who your agents are, if you have changed beneficiary shares, any of those types of things, those people who previously had copies may be saying, am I getting a new copy? And then you've got to maybe have the conversation with them as to why you're not giving them another copy, okay? Disclosure will vary at different stages of life, okay? When you are a very young person in your 30s, 40s, 50s, you aren't necessarily going to share everything because those documents are more likely to change, right? But my clients that are in their 70s, in their 80s, and their 90s, it's really important that their agents understand the documents that they have, when and where they're going to be utilizing those documents, those types of things, okay? Do you disclose who's getting what? Typically, no, right? It's really none of their business, and generally people aren't guaranteed to receive anything. You may spend all of your assets, you may change who your beneficiary designations are, but what I will say is that if you're doing something unexpected, you may want to consider whether to disclose that information during your life, wait and leave a note for them for after your pass to explain your reasoning, keeping in mind that things may change. And we're going to talk a little bit more about that towards the end of this as well, okay? You may also be having separate conversations with the people that are your agents versus the people that are your beneficiaries, okay? We'll talk about who your agents are, but your agents should be understanding the expectations, the role that they have to play, and what their responsibilities are. Beneficiaries are generally going to need less information, right? And so you don't necessarily have to share as much with them. You may not have to share anything with them, but with your agents, that's generally where we're talking about disclosing a little bit more. Here at Keystone, I like to offer to our clients and our trust care members that at any of their signing appointments, if they want their agents to come in to learn about the documents and how they would get used and when they would get used, I like to include that as part of the services that we offer, because oftentimes when you as an individual are having these conversations with your agents and the agents are asking questions, you may feel ill prepared to answer those. In addition, a lot of times our kids don't want to have these conversations with us. You know, they kind of sometimes equate the need for these documents as something terrible is going to happen to you. And while we prepare these documents to prevent any type of issue when that happens, a lot of times kids can be emotional and they don't want to have those conversations. So bringing that into the law office, into a professional setting, makes it feel more like a business transaction and less like an end-of-life conversation, okay? The documents that you will discuss or would be recommended to discuss with people when you feel it's appropriate. So when we're talking about your financial documents, we're talking about your irrevocable trust. If you also have an irrevocable trust, you may be having that conversation too. Your will, also known as last will and testament, your financial power of attorney. And then for your agents, especially, you might be discussing information regarding your assets, where they're located, what valuables do you have, what items do you have that are sentimental value, those types of things, okay? In terms of your healthcare documents, that may be a different set of agents, okay? Your financial people may be different from your healthcare people. Your healthcare power of attorney, your HIPAA authorization, your living will, and if you have a do not resuscitate. Okay, so we're going to go through those documents and kind of what you would share with regards to that information in a little bit more detail. All right, so financial documents, we're talking about what are the responsibilities of your agent, right? When you're choosing an agent, you want to remember that this is not an honorary position, but a job that will take some time and effort. I often get people that are like, I'm worried about hurting my kids' feelings. I feel like I should do it in birth order, those types of things. That is really not what's in your best interest, okay? You want the person that is going to have the similar financial beliefs that you do, that handles their money well, that's going to have the time and ability to manage it in the event that you can't manage it for yourself, and is going to take that job seriously, okay? So please, please, please don't just do it based off of birth order, okay? Sometimes birth order is great, and sometimes that is a good and natural flow, but don't feel like that's a requirement, okay? Agents should also know how the different documents work, and that will help avoid frustration for them, okay? If they are the trustee under the trust and they are the financial power of attorney under the power of attorney documents, those two positions deal with different sets of assets, okay? Your trustee is going to be handling assets that are titled to the trust. Your bank account should be titled to the trust. Your house may be titled to the trust. Your brokerage accounts should be titled to your trust, okay? Your retirement accounts, however, are going to be in your name during your lifetime. So if your agent needs to access that to pay bills, let's say you've been moved into a assisted living facility and you need more money than your income coming in, and we need to pull some of that from an IRA or retirement account, we're going to be using the power of attorney to pull the money out of an account that's in your name, like an IRA or a 401k. That money is then going to be deposited into the trust account, and then they're going to act as the trustee to pay the bills with that money. And so understanding that can help a lot, help people from getting frustrated because they go to the bank with the power of attorney and they want to act as power of attorney for you as trustee of your trust. That doesn't work. That doesn't fly with the bank. They're going to send them away telling them that the power of attorney doesn't work for the trust. And so helping them understand how those two different documents work can really help eliminate some of their frustration and not drain time on things that isn't working correctly. Okay. We also want them to understand the responsibilities and duties to the beneficiaries to avoid any legal and personal conflicts. Okay. During your lifetime, your agents have an obligation to you. Okay. If you are not in a position that you have capacity to understand those things, we generally recommend that your agents are having that information that with regards to how they're spending money, what they're collecting, and like a general accounting, and having those things kind of viewed by a third party, whether that's another family member or whether that's a professional, but somebody to kind of make sure that the trustee or the agent is doing the things that they need to be doing properly for you, right? Once you pass away, their obligation is to the beneficiaries, okay? And so sharing information with the beneficiaries at that point in time is going to be important. They're going to want to give notice that they're acting as trustee. They're going to want to do an inventory. They're going to want to do regular accountings. They're going to want to share information with them, okay? And so you just want to make sure that they understand. I run into a lot of our litigation issues where you've got somebody who's the trustee and they think that they've got sole and exclusive control and they're not sharing anything with the beneficiaries, and that makes everybody really frustrated, okay? Your agents can be helping you during your incapacity, but also they could be helping you at your request, okay? I get a lot of clients where maybe they've lost a spouse and the spouse was the one managing all of the finances, or maybe they just aren't as active. They're not catching things like they used to. They feel like they're missing more and more things. If you're not incapacitated, you don't have to fully step down most times. You can have somebody step up to help you. And so knowing, you know, if they're going to step in to help you, defining what does that look like? What are you paying? What am I paying? Are we meeting monthly to kind of discuss how the assets have been managed and any major changes that we're doing to them? So those are things to definitely talk to your family and your agent about, okay? Your agent should also understand that they've got obligations to your creditors and your beneficiaries after your death, okay? Some people just want to ignore the creditors. That's not okay. Some people want to, you know, try to do things that decrease the beneficiary's interest in the estate. They can't do that either, okay? So you want to make sure that the person that you choose understands these responsibilities and is willing to fulfill those, okay? Why you choose your agents, as I mentioned earlier, similar financial ideology. Those are good things to, you know, that they share the same ideas with regards to savings, how to manage, how to invest, how to handle money, right? Their time and willingness to act. Do they have the ability to take this on? You know, we're fortunate that we live in a world now where a lot of things are auto paid, and so it doesn't take necessarily quite as much time and effort each month to get the bills paid, but there's still some time and effort that needs to go into this. Do they have that time? Are they willing to do that, right? Of course, we want an agent to be trustworthy, okay? We want to know that they're going to do what's in your best interest, that they're going to do what's in the beneficiary's best interest, and that they're not there to just do what's in their best interest, because that obviously is not going to work out very well for anybody, okay? They do have an option to share the responsibilities with others. Generally, I will say to our clients, do not force two of your kids or two of your agents to work together, okay? That can lead to a lot of frustration, complications. They both have to be at the bank at the same time. Sometimes they both have to be on the phone at the same time when dealing with certain things. What I say to clients is let them choose at the time that they need to act as agent. If an agent needs somebody to help them, there's ways to put most of that stuff in place to have two people act as a co-trustee or to share the responsibilities. But if we force them to do that, that ends up in our litigation department quite a bit, which is unfortunate and a large waste of those assets, okay? Also know there are third-party and corporate fiduciaries that are available. They are, they do charge a fee. And Keystone Law Firm recently started that with some of our trust care clients, where we will be your third-party fiduciary in the event that you don't have anybody else that wants the job. And we do, there are a number of people out there that don't have close family members, or all of their family members are their age. And so they're concerned that they're not going to want to take on the job and do those things. So know that those are all things that you want to let your agents know why you've chosen them, and talk to them about those types of things before you finalize them as agents. All right. Another important thing to talk to your family about is, why are you doing a trust? Okay. Here in Arizona, we get a lot of people from out of state that come, either they're snowbirds or they've moved here from out of state. And in other states, the court system isn't necessarily the same as it is in Arizona. In some states, a probate process is very simple. Here in Arizona, it's not as simple. It takes about a stack of papers about that thick. It takes a minimum of a few weeks. So that's assuming that we don't need a court hearing to get the paperwork back. It does become part of the public record. Our clients that file for probate usually almost immediately start getting investors saying that they want to buy their property, and they come back to us and say, how are they even getting this information? Well, they're getting that information because they're trolling the court records, and that's how they're finding the information. So a trust, is a very private thing. And so that's part of the reason here in Arizona to stay out of probate, to keep it private, those types of things, right? Adding a family member as a co-signer or a co-owner of your bank accounts can come with some complications, right? It seems like it's the easy thing to do, but people don't realize the downsides of that, okay? So first of all, adding them on the account can make them, my understanding is a lot of the banks are making them co-owners. They're not just signers, they are owners, okay? So if your co-owner is sued, your money is now subject to garnishment, is now subject to their judgments. And so that can be a very concerning thing, right? Not that any of us expect to name an agent that's going to have those types of issues. But if we just name them on our bank account as an individual account, as a co-owner or a co-signer, they're going to be entitled to receive all of those funds. It's going to be subject to their own garnishments. And when you pass away, that isn't part of your estate. Those assets are now their assets, okay? And so we do see a number of clients that mom named them on the account so that they could run the bills, and now mom's gone and that account is legally theirs, and the other siblings are pretty upset about it, right? If we have it in the name of the trust, and child A is the trustee of the trust, they are not the owner of the trust, okay? And so that's the difference between an individual account and the trust account, is the trust account won't make them an owner, the individual account will make them an owner, okay? In addition, transferring assets to your children during your lifetime can result in additional taxes being paid, okay? So sometimes we get people that want to just put their kids on the house. Let's just transfer the house to the kids right now, right? Well, first of all, we're going to lose a stepped up basis on the house. And so that may result in the kids having to pay capital gains tax at the time that they sell the house, because when you pass away, they're not getting a stepped up basis on that property, okay? The other part of it is that if you do that during your lifetime, technically that's a gift, and probably triggers a gift tax return that should be filed if it's more than, at least as of the end of last year, $19,000 per year per person. So assuming that you have transferred a house that's worth more than $19,000, legally you should be filing a gift tax return to reflect that. So putting it into the trust and letting the kids get it after you pass is a very convenient way to make sure that it gets to them. They get the stepped up basis. There's not triggering a gift tax during your lifetime. Some things like that should definitely be considered. People often feel like that's just an easier way to handle things, and it really isn't, okay? The trust helps us avoid a conservatorship during your lifetime. And that's really an important thing here, especially in Arizona. The conservatorship process is a very lengthy process. It's an expensive process. There is a court-appointed attorney for the ward, which would potentially be you. Usually the person trying to get conservatorship has an attorney. There's a court investigation. At times, the court also will appoint a guardian ad litem to do what's in the ward's best interest. Once you get appointed, and that's after a hearing, hearings are usually at least 3 months out. After you get the hearing and you get appointed as conservator, then you have to submit an inventory, you have to submit a budget, you have to submit a credit report. Every year you have to submit an accounting and get that approved by the court. So those are timely things, they're expensive things. And then once the person dies, you also have to submit a final accounting to the court. You have to do a petition to terminate the conservatorship. With a trust, a lot of those things are still happening. We're still doing an inventory. You should still be doing accountings, but we're not getting court approval. That's not going through the court process to do that, right? It can be a little bit more informal. If you've run everything through one bank account, it's the bank statements with the check register to evidence where everything is, right? And then you guys are confirming within yourselves usually, or if you need a third party bookkeeper or CPA or professional to confirm that all the transactions are legitimate, you can do that, but we're not having to do that all through court. So we really want to avoid the conservatorship with that trust, okay? People think, well, I've got a will and my will is just great. Understand that the will is just instructions to the court. Okay, and so that is still triggering probate through the court. The trust avoids probate, and that's the biggest thing that we really want to try to do. Probate, conservatorship, those are the things that we really want to avoid here in Arizona. And as I mentioned earlier, the trust is private, so it's not part of the public record in terms of who's getting what or how much is in the estate or those types of things. Okay. For your agent, which documents do they use? As I mentioned earlier, the trustee documents for all assets titled to the trust is what they're going to use. It's helpful to have bank statements or other documents that evidence how assets are titled in your, like in our case, in your binder, right? I want to know, is my Wells Fargo account titled into the trust or is it in my name? Because that's going to tell me which documentation I need to take to the bank to access that account, okay? Your power of attorney documents, they are only good during your lifetime. So they do expire at death, and they're only for assets that are still in your name, not in the trust, okay? If the power of attorney is rejected by the financial institution, the next option is the conservatorship through the court action. So we really want to limit what we have to use the power of attorney document for. And from your agent's standpoint, we really want to help them understand that's two different buckets of assets, your trust assets and your individual assets, and they require two different documents to be used to be effective, okay? Healthcare documents. So again, your healthcare power of attorney, your HIPAA agents under that, right? Your healthcare agent responsibilities are to make decisions when you cannot make them for yourself, okay? It's really important that they understand they don't get to overrule you. The doctor is the one who determines whether or not they feel that you have capacity to make your own decisions, okay? They also need to understand the difference between the healthcare documents. The healthcare power of attorney is only used when you can't make decisions for yourself. We have a separate HIPAA authorization that allows your agents to make doctor's appointments, pay medical bills, talk to the doctors, right? So when my family is in the hospital and I'm having to sit there bedside to advocate for everything for them, and the doctors are kind of coming and going as they please, and you never know the timeline, and maybe my family can make the decision, but there's a lot of things that they're not necessarily processing or being able to take everything in at the same time. And so being able to participate in those conversations can be really important to making sure that they're getting the best medical care that they can, okay? Another important aspect is making sure that they understand your wishes and what decisions you might make if you can or could, okay? With our documents, we have a letter of instruction to our healthcare representatives that helps indicate, do you want them to consult with your other family members? Do you want them to get second opinions? How do you feel about living in your home versus living in a family member's home versus living in a facility? What are your thoughts on medications and certain doctors and those types of things? And so married couples, typically, we feel like we can answer most of those questions for each other. It's easier for us to have those conversations with each other. And most people will understand when a spouse makes a decision for you, and will respect that. When you have a child making that decision for you, and perhaps you have other children that have a different opinion, or if you have a friend or another relative that's being asked to make those decisions for you, it's hard for them to know what's the right decision. And these are often very emotional, very tough decisions to make. So to the extent that you can have something in writing that kind of lays out what your general philosophy is with regards to medications, with regards to end-of-life decisions, those types of things, you want to make sure that you can kind of communicate that. I like to point out that here in Arizona, the healthcare documents can be registered with the Arizona Healthcare Registry, and that we don't have to have the original when you go to the hospital or somebody is trying to exercise those things. Copies are acceptable, okay? So when you're choosing your agents, will your agents honor your wishes? You know, I often hear from clients that this kid's going to pull the plug too soon and that kid's never going to pull the plug. We want to make sure that they're going to follow what your wishes are. Often with our medical agents, our healthcare agents, we want them to be nearby or willing to come, okay? If you've ever spent time in a hospital, it's a 24/7 type of cycle. There's constantly doctors and nurses and information being given, and you need somebody who's going to be able to advocate for you, because if you're inconveniencing somebody to fly in from out of state, that can be difficult to ask of somebody. And a lot of us will be like, oh, we're fine. And you know, I joke that we're in a wet bed and we haven't eaten in 3 days and we're jaundiced, but nobody's there to see that. If you don't have somebody who's nearby or willing to come, then the next question is, do they have any medical knowledge? You know, if your agent is a medical person and they can call and talk to a doctor or a medical staff member and get the stats and get the information and understand what all of that means, that's great. You know, maybe they don't have to come, but for a lot of us, we're going to need that person that's going to be able to come and sit with us at the hospital and get all the information, okay? The other thing is, will they communicate with whomever you want to be consulted in decision-making? You know, if you've got some children that are at odds with each other and you want to make sure that everybody is on the same page when it comes to your medical decisions, you have to make sure that the person that you've chosen is going to be willing to communicate with everybody as you want, okay? And finally, will your healthcare agents be able to make the tough choices? You know, as I mentioned, these medical decisions can be very emotional. They can be very tough. You are often putting somebody in a tough choice for end-of-life decisions, and will they be able to make that decision? So that's something to talk to them about and help understand what your expectations are, okay? It is important that they understand the differences between the different documents, okay? Your healthcare power of attorney does not overrule you if you can make decisions for yourself. It is generally one person at a time to make decisions. You can request everyone discuss it, but ultimately make one person make the decision. I often have clients that say, I want both of my kids or all of my kids to make that decision, but the problem that you potentially run into is that if the doctor walks into the room and says, this is my suggested cause, process, and one kid says, that sounds great, and the other kid says, I don't know, and then the doctor, you ultimately come back and go, yeah, this is the decision we made. The doctor could say, you know what, I'm concerned that one of you were kind of pressured into making that decision, and I don't know that you guys are on the same page, and I'm not going to take either of yours word for it. You're going to have to go to court and get a guardian appointed, right? And the guardian's similar to the conservatorship process. The process is very much the same, only with the guardianship, just every year we're submitting a medical report and a report to the court with regards to the care that you've received during the prior year. So I generally recommend to clients, just name one person at a time. Explain to the kids, like, the plan is for you all to consult and come to that decision together, but I need one person that can go forward and talk to the doctor about making that ultimate decision, okay? Remember that the doctor determines capacity, not the agent. So your agent's not getting to overrule you, right? The healthcare power of attorney, as I mentioned, does help avoid needing a guardianship through the court. The last part is your healthcare power of attorney can have you designate whether you prefer burial or cremation, okay? Here in Arizona, the default is burial. And if you want cremation and you don't have that in your documentation, they may require all of your family members to sign off on that. So if you're married, it may just be your spouse that signs off on it. But if you're not married and it's your kids, you may have to have all of your kids sign off on that. Sometimes if we have kids that have incapacity issues or that we don't know how to locate them, or just they aren't in communication with the rest of the family, that may not be something that you want to leave up to chance, and you really want to designate that, okay? Your HIPAA authorization, on the other hand, is a little bit different, okay? Everyone that you list can access the information, right? So to the extent that you're feeling bad that you're doing one kid at a time as your healthcare power of attorney, you can list all of your kids on the HIPAA authorization, and they can all talk to the medical staff. They can all access the information that they may need to help in making that decision and ask the questions that they feel like they want to ask. I often find that I feel like the HIPAA authorization is one of those places that really helps the kids feel like they're able to participate, okay? Your HIPAA agents can also make doctor's appointments. They can pay medical bills. It is often really critical to obtaining the doctor's confirmation of an incapacity if your agent needs to start handling your finances. So going back to your trustee, if your successor trustee needs to step in because they believe that you're incapacitated, your successor trustee needs to have a doctor's note saying that you can no longer make financial decisions for yourself. And in order to get that, they're going to need this HIPAA authorization for that doctor to release that information to them. So it's really important. Without that, they may not be able to get that information that they need. And so again, understanding you're not going in as the healthcare power of attorney necessarily. You may be going in as the HIPAA agent to get that information, okay? Additional healthcare documents, the living will, okay? So this is not your last will and testament. It doesn't discuss the distributions of your assets. And I often hear people confuse those two terms. I have a living will. I have a living will. Okay, your living will talks about your end of life. It doesn't talk about your assets and what happens after your death, okay? I refer to the living will as the don't drag me out document, okay? It talks about end of life decisions. It talks about pain relief. It talks about if you are at the end of your life with a terminal illness and your death is imminent, or you've been in a persistent vegetative state, you're brain dead, those types of things, whether or not you want that dragged out, whether or not you want any kind of artificial hydration, those types of things, okay? The living will is more appropriate for most circumstances because most people can kind of agree that they don't want to be dragged out at the end of their life, but they don't want to be in pain, okay? Discussing your end of life wishes with your agents and with your family is really helpful. We want to avoid having misunderstandings by having something in writing. You know, I've got a sister. I know that there are times that, you know, my mom will tell us things and we might hear it a little bit differently. You multiply that by more children and there's more chances for that kind of misunderstanding. So having something in writing that your agent can kind of refer to and confirm this is what your wishes are can be really helpful, okay? The do not resuscitate, okay, completely different document. This is what I call don't bring me back. Don't attempt to bring me back from death. I've died, I've flatlined. Whether or not they're going to try CPR procedures to try to bring you back to life, okay? Technically, this is a medical order. It's not something that we do here in the law office. You should be discussing it with your physician, not your attorney, okay? It is not appropriate in all circumstances, right? A 30-year-old is not going to have a do not resuscitate. Somebody who maybe is in their 90s, somebody who has a terminal illness, somebody who has very fragile bones, those are all reasons to my knowledge of why you would have it. But make sure that you are also talking to your kids and your agents to let them know if you have it, if you want it, what your thoughts are on it, right? Some people are very much wanting it. Some people don't want it. But I also have found recently that some clients don't understand the difference between the living will and the do not resuscitate. And so they've gone to the hospital and they asked, do you have a DNR? And they told the hospital staff yes, thinking that that was their living will. And then when they told them that they wouldn't try to resuscitate them if something happened to them, they were very concerned about that, because at the end of the day, they did not want a DNR. They just wanted the living will. Okay, so making sure that you understand the differences and that your agent understands the differences can be really important. All right. Additional information that I want to make sure that you guys have. How do they find the information you do not want to share now? Okay, it's completely fine to not give them every password, every account balance, every safe combination right now, right? But let them know how they're going to be able to access it, okay? So that in that event, they know, where am I going to find that information, okay? And keep in mind, they're going to need access to your phones. Our phones have our calendars in them. They have our contacts in them. They have a lot of information, and there are now some ways to leave trusted or legacy contacts in your phone so that they can access that when it's appropriate. We don't need them to access it right now, but when it's appropriate, they'd be able to do that. Similarly with your computers, your emails, those are pieces of information that we're going to need the passwords to. Again, you may not want to provide that to them right now. And those are things that update periodically, right? So it's not a matter of saying to them, here's my password. It's a matter of saying to them, I keep a log of my passwords in the safe or on a flash drive, in an Excel spreadsheet, however it is that you do it. And if you include the information and the locations of where they can find that in your binder, it just makes it all the more secure that they're going to be able to figure their way to the information when they need to, okay? The other thing we want them to know is, how do they step in if an emergency occurs, okay? Is there going to be a packet regarding your income and expenses someplace? Your bills, who, when, how are they paid? Do you have a tax preparer or other professionals they should know about, right? I really like the idea of just having a list of your monthly bills. Are they automatically paid? Are they charged to a credit card? Are you writing a check? Just kind of that summary. Who does your electric bill get paid to? SRP, APS? Some of those types of things are things that I'm finding that the successor trustees are coming into us and saying that's really where they're getting hung up, because keep in mind, we don't necessarily get this stuff through the mail anymore, right? It used to be you could say, wait 6 months, you'll get everything through the mail. Nowadays, not everything comes to us through the mail. It may be coming to you via email. It may be not coming to you at all. And so we want to make sure that they've got a way to step in, understand what they need to do from a financial standpoint, especially if at the same time they're trying to deal with a medical emergency, okay? But also letting them know, where do they find the binder? Should they be reaching out to Keystone Law Firm? Who should they be reaching out to in terms of those types of things? So if an emergency occurs, you want to kind of give them the, here's what I need you to do type of thing, okay? Also be aware that different actions are taken if a parent becomes incapacitated versus after they pass away, okay? Again, feel free to invite them to a meeting with the attorney to hear the explanations and ask the questions, but there are two different roadmaps in terms of what needs to happen when a person is still alive and you're managing the money for them, and after they've passed away and you're managing the money for the beneficiaries, okay? Trustees can be compensated for their time, right? So share your expectations with regarding compensation. You know, some family members figure their kids won't get paid. Some family members want their kids to get paid. Some people have friends doing it and they've had, you know, language in their trust with regards to what they could or should get paid. Those types of things should just go ahead and be communicated in there. Sometimes I have people that are like, I want to give this person $10,000 because they're going to be acting as trustee. And I have to say to them, okay, so first of all, they can be compensated for the actual time they work. And second of all, if I put a specific gift in there of $10,000 and they don't actually end up acting as trustee, you're not accomplishing what you're thinking you're accomplishing. So just make sure that you're, you know, identifying that within your documentation and kind of sharing those expectations with your family, okay? Trustees can pay for the professionals from the trust assets, so they are allowed to use the trust assets to pay the tax person, to pay the lawyer, to pay for appraisals, to pay for financial advisor, real estate, agent, those types of things. So know that they don't have to be completely out of pocket for everything. And explaining some of that to them will help them understand that the burden doesn't have to completely fall squarely on them initially. Share if you've made any final arrangements. Do you have a burial or cremation plan, pre-planned arrangements? Are you donating your body? What are your desires for services? You know, some people want a very traditional church service. Some people want something a little bit more informal. Give them some direction on your preferences, right? Because everybody's going to want to make sure that they're honoring you in the way that you want to be honored. And people may have different ideas of what that looks like to them. But at the end of the day, we want to make sure that your agents are doing what it looks like to you. And the best way for that to happen is for you to communicate that, okay? Keep in mind, if you're a trust care member with Keystone, let them know that a meeting that they can have with the attorney here in the office upon your incapacity or death is included in your membership, right? So if you're showing signs of incapacity or you've passed away, the first thing they can do is schedule a meeting with us, and we'll walk them through how to go through the next steps, what the full expectation is, and what their options are, okay? And so that can be really helpful to just kind of relieve some of the stress of the unknown. Sometimes I just do that with the agent. Sometimes I like to do it with the whole family and let the whole family know what are the expectations, especially if you've passed away. Andrea, my case manager, and I like to have those conversations with those families to help them understand what are the expectations, what are the timelines. You know, please don't count your money before you receive it, because we don't know until the creditor period is done, until the taxes are filed, until the house is sold. We don't know what you may actually be receiving. And so there's some things that have to happen before we can make distributions. And oftentimes beneficiaries are eager to receive those funds, but there are some legal processes that need to happen before those distributions can be made. And so again, helping them to understand those types of things are important with regards to that, okay? Transparency. So transparency is often key, but it's not always immediately needed, right? If you think they're going to be surprised by the information they find in your estate plan, you might want to help them understand your reasoning now or later, right? For some people, they feel like they already know now, or they're having conversations with them now. For some people, they're writing a note, they're leaving something for the longer term, right? Just always keep in mind that your wishes, your wishes are now, and you might change those in the future, okay? So recently we had a client that mom had written a letter saying how disappointed she was with all these things, and how upset she was by the things that her child had done. And now mom is incapacitated, and that same child is taking care of her. And so it was kind of eye-opening for the child to hear all these things. But it was kind of okay, now we've let that go, right? I have other clients that maybe they're disinheriting some kids, or they're just not providing for them, and are leaving a message with regards to why are they doing that. You know, some families already know. Some families don't necessarily know, or, you know, don't care to know type of thing. If you write a letter to your loved ones explaining your reasoning behind something, try to keep that information updated if things changed. I'm always really pleased when people have come in one year and disinherited somebody, and the next year that relationship has improved, and they're putting them back in. So no, things can change, but don't lose sight of those letters or that information, okay? Also, make sure your agents understand the level of transparency that's expected from them to the beneficiaries, and let your beneficiaries know they're entitled to information from the agents. Like I think I mentioned already, a lot of times our litigation is about trustees who think that they can just do what they want and that they don't have to share the information with the beneficiaries. And then the beneficiaries are really frustrated by the lack of information and not knowing what's going on. They're not having information shared with them. They don't understand what the process is. And that can, you know, really cause a lot of internal turmoil between the families. And a lot of times that turmoil is already there a little bit. And so we want to make sure that, you know, we're picking the right agents so that we're not increasing that turmoil, that we're helping them understand the expectations of not only you, but also the law with regards to sharing information, with regards to a trust administration process when you have passed away, and how that works and what information they're entitled to. Okay, so the information that you give to your agents may be a lot more than what you give to your beneficiaries, especially during your lifetime. But there's a lot of information here, and for people that don't have their own estate plans, may not necessarily understand the different documents, their responsibilities of acting in those roles. And so it's really important that when you're choosing somebody, especially our kids that may not have their own estate plan, that we're kind of communicating to them the importance of what these roles are, what their obligations are, and that it's important that they're being true to the beneficiaries with regards to it. Okay. So we do have about 15 minutes left. Keep in mind that this is a webinar that not only is public to those of you who are on here today, and I appreciate you guys for joining us, but also will be on our YouTube website. So if you would like to present a question using the chat feature, or even possibly raise your hand and I can call on you and you can just unmute yourself. But make sure that you're doing that in a way that is not giving away detailed information about your personal stuff, please, because we don't want that out on the web, so to speak. For those of you who are newer to some of our webinars, know that we've got a bunch of other webinars that Francisco does some, Carmi, our financial advisor, has done a few, and that I have done in the last couple of months, and those are all located on our Keystone Law Firm's YouTube channel, and so you can search those and watch those at your convenience as well. So anybody with questions? All right, I'm not seeing any questions. Alexis, do you mind popping in and letting us know what your next, actually, I'm going to take a question from Diane first, and then I'll have you share with everybody the next webinar that we have. All right, Diane, can you unmute yourself maybe? I'm not sure. It doesn't let me unmute you.
Can you hear me?
There you are. Hi, how are you?
I'm fine, thank you. It was very interesting. Can you please tell me what you meant by the membership and how you become one?
Sure. So here at Keystone Law Firm, when you engage us for a estate plan package, for a year after you're signing, you're included in the Trust Care membership. Unless you've come to us through like a legal services, like ARAG, through the employer. After the first year, there's a membership fee that people can pay annually, and that membership fee includes a meeting with us every year. It includes any changes to the documents that need to be made that year, as well as a meeting with the family during an incapacity or death. Unfortunately, in some years, people may have both. They could have both the incapacity issue and then the death issue, but that's all part of our Trust Care program. So I'd be happy to have Alexis reach out to you, Diane, about that information more if you'd like.
Okay, thank you.
Absolutely. All right, Alexis, are you there? Can you join us with what our next webinar is?
Sure thing, Michelle. Perfect. So the next one is going to be the webinar, Mom Has Dementia, Now What? That one's hosted by Francisco on the 20th of February at noon. You guys should already received an invite for that one. If not, I'm going to drop it here in the chat for you guys to have that. And then the one afterwards is What Happens to Taxes When One Spouse is Gone? That one's hosted by Carmi Gutman, our financial advisor here at the firm. And that one's going to be on the 24th of February at noon as well. So those are the next couple of webinars we have going on. And I'll drop in the registration link for you guys to join.
Thanks, Carmi. We really appreciate you all giving us your time today. I hope you learned something from today's webinar. That's really our goal. And those of you that are Trust Care clients, if you have any additional questions, feel free to reach out to us and we'll do our best to answer them. We really appreciate your time today. And go off and have a great day and a great week. Thanks again.